because one simply needs to also appreciate that you can, as Mr. Wildman did this morning and other lawyers would have done, is to say, why are we here? And there are judges, most erudite judges in our court system, that they respect for the Constitution, and that's what we must understand. This is about the Constitution. It's about the rule of law. It's not a personal attack on the office holder. It's about procedure that must be respected.
That's correct.
If we are right.
I took this morning. I explained to the judge it's a constitutional point. And she had to set a new date for the case.
So where do we go from here?
Well, as I say, I think good sense should prevail Monday morning, and I hear some arguments about appointing an acting DPP. That is not correct. The Constitution does not make provision for an acting DPP.
Right.
So you can't. The Constitution does not make provision for an acting DPP. You only have to you can only make a full appointment as DPP. So right now, no one in the DPP's office right now can sign a paper right now. Nobody can sign a paper because there's no DPP in place. So none of the deputies or senior deputies can sign any paper down there. They'll be getting in trouble.
No, so you're telling me that the entire government jurisdictional process is on a standstill?
That's correct, because no deputy can sign when there's no DPP in place. You see, the concept of the deputy DPP or the senior deputy is not known to the Constitution. That is an administrative concept.
That came about. So the deputy is not in the Constitution.
No, but to be fair, the Constitution makes provisions. That's why it makes provisions for somebody to act on if they are qualified. Until the office.
When there's a sitting holder of the office.
No, I know, but if the sitting holder for any reason is unable to continue.
There is no.
No. I'm saying. Wait, listen. If the office becomes vacant, I can read the section, because it's 96 3. It says when it becomes vacant, as it is now, there's whoever is qualified. I could give you some names, like Miss Pike, and others. But I'm just saying, if these persons, for instance, they are qualified, they have this experience. Did I say Miss Pike? I don't know. I said that out loud. My apologies.
If there is no DPP, just like, for example, let me give you an example.
Yes, the concept. I love this program tonight.
The concept of the DPP and its appointment follows the concept of the Chief Justice. You remember when Justice Sykes was appointed?
Where he was acting. Yes.
He couldn't, you know why they had to quickly appoint him? Because people like me made the point that there was no scope for an acting Chief Justice. That's why they had to quickly go for the Chief Justice and appoint the full Chief Justice.
I'm retired.
That is
right. But what I'm saying is, but section 96.3 is a little bit different. Let me just read it. Let me just read it for educational purpose. If the office of Director of Public Prosecutions is vacant, as it is now, or the holder of that office is for any reason unable to perform the functions thereof, a person qualified for appointment to that office may be appointed to act therein, and any person so appointed shall, subject to the provisions of subsection 1 of this section, continue to act until the office of Director of Public Prosecutions is filled. Is filled, or as the case may be, until the Director of Public Prosecution has resumed the functions of his or her office, and the appointment of that person is revoked by the Governor General or acting. So, the steps section 96.3, the steps that ought to be taken, I'm humbly suggesting, would be, rather than going into a losing battle repeating, because insanity is doing the same thing over and over. The government has now gone into a track record where when they don't like the rulings, it's a sign of disrespect to the court to challenge something that you know you're not going to challenge, i.e. the Everton Douglas matter. They did a whole appeal and there was no legal basis to do it. So if somebody asks me, can they appeal? Yeah, you can appeal anything. All you're going to do is, taxpayers beware, you're racking up costs. And with the ilk of lawyers that are on this particular thing, we're going to be spending millions of dollars to pay costs for an appeal that they are going to lose. It's a simple, but let me read back the 96 for you. That is where we're at, and that's a conversation we have to have, is that while it is the government has nothing to lose, the people, we have something to lose, because we are going to pay the lawyers, we are going to pay the claimants' attorneys for the government to go on a fishing expedition.
Let me rephrase for the thousands watching in layman terms. If them plan to go to appeal, we Jamaican people have to go pay for the lawyer them for the appeal, right, Tara?
Correct.
What you say?
Yes, that's correct.
But that's not right to we poor people when the Supreme Court don't deal with that already.
Well, that's a policy decision that the government will have to make. But the point is this, you know, is that the Constitution, the language of the Constitution, is that it contemplates that there's a hold of the office of DPP.
Yes.
For example, when the DPP is, like I said, the DPP is off on vacation, you appoint somebody to act. That is permissible.
Yes.
That is correct. Okay?
There is a clear vacancy.
But where there's a clear vacancy, what should be done as the case of the Chief Justice is that the person must be appointed as DPP. Now, that the DPP is sick, you know. If DPP is sick, then clearly somebody can be appointed to act. But we have court, because you go back to that section of the Constitution which says, and it's another area of debate, whether what the DPP has done over the time that she was there.
I want to get to that.
Yes. Everything is tied up here.
I saw another turn. When name Christopher Townsend.
Yes.
Questioning from the time she got the second extension to present. If the cases that she ruled over during that time, they were constitutional.
That's the point I'm making. And that's another area of debate, because it is my position that everything that she have done since this amendment and extension would be a nullity. That is, it would void. And the reason for that reasoning comes from the Paul Chen-Young case.
What is the Paul Chen-Young case?
That's a case where a judge, the judge of the Court of Appeal, had sat and gave judgment after they had retired. After they had retired. And the question is whether the judgment that they gave was constitutional, legal. And the court...
So you're saying the Paul Chen-Young case where the retired judge gave the judgment?
Yes.
They question whether or not the judgment had any effect.
That is correct. And it was held to be void.
So wait, let me say, No. We just want Jamaica, no.
No, you know, Andre, you're going to have your students curse me because you are making me laugh, and it's not funny.
No, I said, we have to ask. We just want to sure say the bangarang a bangarang. So say Mr. Wildman and Mr. Buchanan.
Yes.
From
that is it, that is it.
Yes.
Yeah, big youth. A celebration, big birthday
the ruling where she did make.
Yes.
Set him out and big underscore.
That is part of my claim 2 years. That's part of that. And that's the effect of the ruling today. That when something is declared to be void, in law, it is said to have never happened. It is void ab initio. As is man's death.
Yes, ab initio. To the extent as if it never existed.
It never occurred.
Agreed.
Jesus. But a serious case them there now.
That's correct.
But M.O.D makes it talk, I said.
You know, I would say this though, Mr. Wildman, I'm so happy that you're here because I would wonder, I would have sought your guidance on this in any event.
Yes.
The section 96.2, and I have been grappling with this. I share your view on the void ab initio. That's how I understand it. That's the school of thought.
And listen to the reasoning of that section now.
Yeah, so this section...
And this is very important.
This section is what I grapple with. Because section
92...
Section 92... Yeah, but this is what causes the debate now on whether this is so. It says...
You can read it out for me,
I'm going to... Nothing done by the Director of Public Prosecutions shall be invalid by reason only that he has attained or she has attained the age at which she is required by this section to vacate her office.
That's correct.
The question to ask, I want you to address that now. Yes.
That section has been judicially considered. Yes. And the effect of that is this. Where the office holder was put on notice that the challenge is going to take place.
Yes.
And the office holder insists on remaining in office. Then the section cannot avail him. So in this case, the government would have been put on notice that if Ms. Llewellyn's appointment is declared to be void, then
all her actions is ab initio, right? It cannot be said.
They have been put on notice.
Yes.
So you're saying she didn't get the notice already, so anything she do from then to now.
That is correct.
And it simply means also, that the course to be taken now is to ensure that someone, as Mr. Wildman says, is immediately put into the office properly.
Yes.
In the interest of justice. I'm of the view that somebody could act. I will yield to senior counsel, but in any event, it would appear to save the integrity of the office. Someone else has to be at the wheel. Based on that. Otherwise, we'd be going in the territory where constitutional breaches would follow.
Why the acting thing is dangerous. I was involved in a case in Grenada.
Yes.
Where a similar situation occurred, where the Malcolm Holdit case, where he was put on contract, which is like an acting, and the court, Eastern Caribbean Court of Appeal, declared that the appointment was void. Because when you put that DPP on contract, they say, you made the DPP beholden.
Thank you so much for the roses, appreciate it.
That case, I have that case. Okay? The judgment was delivered by former head of the CCJ, Sir Dennis Barron, to put the DPP on contract or acting would amount to be tantamount to.
Yes, if she's even on a contract, it would have not.
It would be wrong.
So that means I want to ask another question. Just being, so all of them, they raise that pay what she get from last year to now. She not for go return it.
One thing about the public.
Let us answer that.
One thing about the public.
I would not agree that she has to pay back that. You know why? Because that is between she and the government. So she can sue the government. Say you put me in a job and I work here to pay me. So there are two separate issues. But for the purpose of the appointment itself, that the appointment to be void. But she can say to the government, you put me there, you have to pay me, I work. So there are two separate issues.
And she would be right, respectfully, to demand her pay. And she has actually done the work. There are conflicting issues, so people have to learn to separate it.
So she can't be compelled to return any money.
Right.
But what is clear is that she can't continue.
Yeah. Wow. So she can't continue. Can we play the video of Elroy Chuck talking to them? And then play the video of Elroy Chuck, producer, please, and thank you.
Justice Minister Delroy Chuck says come next week, the government will be filing documents to appeal the ruling handed down by the Constitutional Court.
We do not agree with that part of the ruling. Position is that we intend to appeal early next week, so the matter will remain until the Court of Appeal rules.
The ruling means that Director of Public Prosecution Paula Llewellyn's appointment is null and void. When our news team visited the minister, the 58-page ruling was spread across his desk. He admitted to not fully reading the document as yet, but believed the government has a solid case. Minister Chuck rubbished the argument that the DPP received a second extension in her tenure. The DPP should have demitted office when she turned 60. However, she was granted an extension in 2020. That ended last year. The minister explained that when the government passed the amendment, it gave her the opportunity to work up to age 65.
This is a new act to replace the existing provisions in the Constitution. It stands on its own. And in those circumstances, the DPP applied to continue to age 65 under this amended Constitution and has nothing to do with any additional extension.
Justice Minister Delroy Chuck says despite the ruling this morning, the amendments to the legislation was not rushed. The government would have passed the legislation last year using its majority in both the lower and upper house. The opposition, on the other hand, said it was not consulted.
There's no doubt that we try to consult the opposition as much as possible. But there comes a point, after you consult, you must make a decision. I think the opposition tries to milk as much political capital out of it, which I think is totally unnecessary.
My case no void. Them now give me back $520,000.
It's a simple amendment raising the age from 60 to 65, which should have been done 10 years ago. And I don't think that was rushed.
As it relates to what happens now, well, the minister says it will be business as usual. But there are concerns about the impact the ruling could have on several high-profile cases currently before the court. We asked the minister, should the public be worried?
No, not at all. As I say, the status quo remains. And until the Court of Appeal rules, I don't think we have to act differently.
Jamila Maitland, TVJ News.
Gentlemen, her boss is saying she can't go back and work Monday.
No, let me respond to a couple of things there. In fact, Mr. Chuck defeated his own argument. One, you heard he said, continue. The amendment makes her able to continue. That defeats his case. Because that's exactly the point we are making, which I have made in my claim and which also came out in this judgment. It means he's conceding that Ms. Llewellyn's appointment emanated not from the amendment, but from the old provision. He's making that concession. So let me repeat. He's conceding in that statement when he said it allows her to continue, that her appointment ab initio emanates not from the amendment, but from the old 96 one. And in that concession, it means that the strictures of 96 1 apply. That old 96. And secondly, it means that the new amendment cannot have retroactive effect to supersede the old 96 one. So he has defeated his own argument in that clip. Secondly, or thirdly, it can't be business as usual, as he says, for the following reason. You can't get a stay and an appeal does not operate as a stay. So it can't be business as usual. It means that he's in a dilemma there. You have a vacancy to be filled by virtue of that ruling, and so what he should be doing now to protect the integrity of the Constitution and the integrity of the criminal justice system, to have an immediate appointment to the office of DPP.
Should he be spending more time focusing on getting a new DPP?
That is what should be done today. That is what should be done today. That is correct. That is correct. So it can't be business as usual as he's advocating there. It will not be. Because when you go to court Monday morning, and all the judges say, come, say, I will not hear you. As was said today. In fact, I heard that.
In St. Anne, the judge.
I heard that in the own circuit court today. After the ruling, the DPP went to a court and the judge told us, I can't hear you because who are you?
What you said?
Yes, I heard that today.
What you said, Mr. Wildman?
That the DPP went to a judge in the Supreme Court today and the judge said, who are you? And she said, the DPP judge said, no, I can't hear you.
What? Bangarang. So that happened in the circuit court today?
Today.
That's the state of affairs across the country.
Yes.
And that's put up breaking news. Breaking news. She going at the Lord Jesus. So she going at the court.
Yes.
And she go do case.
Yes.
And the judge looked at her.
I said, who are you?
Boy, oh boy.